Rethinking the Field of Automatic Prediction of Court Decisions. This is the work that has just been published in the AI and Law Journal. We co-authored it with Martijn Willing and Michel Vos. So it's available. You can have a look at it after the talk, or maybe you've already seen it. So basically, we're all here today. So I assume that even if you don't work in the field of predicting court decisions, that you've seen that it's really dominating the industry now, and there has been a lot of work in academic work in this field. And when I talk, I'm going to be talking about academic research in this field today. And when I talk about predicting court decisions, I mean using natural language processing and mainly machine learning in that sense. So there has been systems that predict court decisions, but not so much with the NLP. The real paper that sort of started the boom probably was Aletas et al. That predicted decisions of the European Court of Human Rights in 2016. And then we can see that it really started being more and more cases all the time. So some more cases in 2017, a bit less than 18, but really exploded in 2019 and 2020. However, the majority of this research is done on the European Court of Human Rights. So while it looks like there's a lot of research on different kind of courts, it's not necessarily the case. So there's really this focus on European Court of Human Rights, including the work that we've done a lot. And really it is probably largely because all the data there is available and in English. And since there were already some benchmarks that people started trying to improve on the scores rather than expand to other courts. I've had complaints before about the slide that I put the EU flag next to European Court of Human Rights research. It's just a representation of European Court of Human Rights judges on more than EU countries, but nonetheless. Moreover, all these papers that do prediction court decisions, the majority of them show quite high scores, sometimes up to 100%, 98% F score, and so on. So I also added some of the 2021 cases when we submitted this paper. This is the ones that we've had, but I'm very sure there's more by now. But I think this is quite representative of how it is going. So I will very briefly talk about our previous research, so we all on the same page and understand what I mean when I talk about research on predicting a court decision. This is our paper that we published a couple of years ago, but most of the research is done in a sort of similar manner. And I want to present an example so that we understand sort of what goes into it, what the outputs are, and what the process is. So I'm sure many of you understand how it works, but nonetheless, so we're all on the same page. I'd like to present like a little example of how it's done. So again, so on the same page, this is predicting decisions of the European Court of Human Rights. European Court of Human Rights judges on the Convention on European Convention on Human Rights. These are mostly cases of individual versus the state, except for a few exceptions. Right now, there's a case of Netherlands versus Russia for shooting down the plane. So that happens, but the very vast majority of cases, individual versus state. There's 47 states, more than just EU, and every case is judged by 3, 7, or 17 judges, depending on the complexity of the case. So when we say predicting court decisions, at least in our paper, what we're trying to achieve is to see, okay, if we have this judges and it's judged by a specific section, and we can identify some important facts, like it was a drug-related offense, there was imprisonment, a fine, and some other facts that based on that information, we can with a certain degree of certainty say, okay, there's likely been a violation of human rights. So this is our goal. We're not trying to make decisions. This is exclusively predicting decisions and trying to understand what contributes to that prediction more than anything else. So the process of doing so, this is going to be a very simplified and very quick run through of how it's done. We download the data, we process it, pre-process it, we balance the data. In our case, that was necessary. Then we have the training machine learning system, and then predicting of the court decision. So the way that a standard case in the European Court of Human Rights looks like, it's X versus Netherlands. It has a section info and which describes the date, the judge, who the judgment, who the judges are, and some formal information. Then procedure, it describes what the potential victim or the applicant went through before they got to European Court of Human Rights, since they had to first seek a domestic remedy, and then the facts, which include the facts from both parties and after investigation. So additionally, there's the law part, which contains the arguments of the court. However, it's very often also contains the verdict itself. So the court, for instance, the text, for instance, will say the court thinks that there was a violation of Article 6 because of this, this, and that. So it already, with the arguments, contains the verdict. Then there's the very structured verdict that says the court holds that this article has been violated and so on. And then there's sometimes dissenting and concurrent opinions of the judges. So that's what goes into the model. So one more thing about European Court of Human Rights is that it mostly judges full violation of human rights, because the cases that would be judged in no violation don't go through admissibility stages very often. So we need to remove some of the cases from the violation pool so that our model actually learns to distinguish between the two better. This is called undersampling. So in the end, for training, what the system does is that it takes the words and phrases. This is how we specify the input from each class, violation, no violation, and then tries to separate. We use the linear SVM here, but it could be a variety of different models. Tries to separate text with documents with different kind of characteristics that are more prevalent in a violation or no violation case. And then in the end, to make a prediction, a new case that hasn't been seen is presented to the system, and then it tries to hopefully correctly guess or predict whether there was a violation or no violation. So this is pretty much how most of these models will work. They will maybe have different inputs, different models that separate the classes, but nonetheless, this is how it's going to work. In our paper, we had 3 experiments. I'm going to just talk very briefly about one of them because it's an old paper. This is not what the talk is about, basically, on predicting decisions. And then we could do it with quite a high accuracy of an average 77%. So once again, quite a good experiment. Probably could be better, but this was sort of an early paper and more of a proof of concept idea. And then we can also, with the system that we use, we can also go back and look, okay, what did the machine learning system sort of use as the predictors for violation, or for no violation. We can see some useful information like forensic medical asylum seeker applicant suffered for Article 3 prohibition of torture, also some rubbish like March 2012, but nonetheless, we could go back and see what has been used. So that was very brief. So I keep saying we've been predicting court decision. However, did we actually do predicting? So this is once again the case of a standard case before the European Court of Human Rights. What we've used is procedure and facts of the case. But we only took the final cases, final judgments that were already made, and classified them into different categories, whether they have violation or no violation. But using this information, we have no way to actually predict future court decisions. We can try to emulate this information, but this is a completely different task, and it's also a very complicated task. So while we say in predicting, it's not actually what we're doing. So one of the reasons that it seems that everybody keeps calling it predicting is because in natural language processing, that is the term for coming up with the label. You give the already trained model a new case, and it predicts what label it will have, and that's a correct term in NLP. However, in real world, it really doesn't represent what's actually happening. So we came up with 3 new terms for how to categorize different research that claims to be predicting court decisions, and I'm going to be talking about each one of them separately now. So these are identification, categorization, and forecasting. And so identification is the task of identifying the verdict within the full text of judgment. So it's just basically finding the verdict, the words of the verdict in the text. Then categorization, which is categorizing court decisions based on the outcome by using the textual information that is published in the final judgment. This is what we've actually done in the research that I've just described to you. And it can be extremely useful because you can use that to try to find patterns within the court judgments to see what influences certain decisions. So identify predictors, but it's not really predicting future court decisions. But then what we really think of as normal people and not NLP is when we say predicting court decision, we expect that it means forecasting court decision. So determining the verdict of the court based on some textual information, because we use NLP, but based on the documents that are available before the verdict is made. So that can be, for instance, information from the lower court or submissions by the parties or any other legal documents that are available before the judgment is actually made. So on the example of the case, let's call it just more or less what a case would look like in any other court. Of course, some of these parts will be different, but it generally would be like this. Then for identification, what we would like to use is the verdict itself. If there is any structural information or some, like from my experience, for instance, with Dutch case law, sometimes it's not a trivial task at all to find the verdict itself in the case, and it could be extremely useful. For instance, I worked also with eviction cases in Dutch case law, and just finding eviction cases and finding cases in which a person has actually been evicted is quite a challenge. And I think it is for, in a lot of domains and a lot of courts, it can be hard to just find the verdict itself if the cases are published without that kind of metadata. But for identifying the verdict, you can really use all the case, if you'd like, all the text. There's no problem there as long as you find the verdict. It's also not necessarily necessary to use machine learning for that. Sometimes a simple information extraction, regular expressions can really work pretty decently here. Really depends on the court, the language, and so on. So this would be the categorization, the identification for categorization. This is again the same as what we've done in the in our research in previous paper, and just in the paper that we published, we used, I've looked up right before the presentation, we used the word predict 97 times, and now we're really, I guess, using that word. So for categorization, you mostly use facts of the case or anything that does not contain the verdict. Can be procedure, any information about the court, but not really anything that contains the verdict. Sometimes it can be arguments of the court if they don't contain the verdict, but I feel like the majority of cases, there will be some reference to the verdict there. And basically what you really want to do there is try to build such a system where you can look back and see what predictors are. So because so yeah, you can really use facts, because if you just categorize cases into, like, for instance, violation or no violation, or eviction or no eviction, or whatever cases you've got, then unless you have any information to explain how you came up with that prediction, what you're doing is really just sorting documents into two stacks with different verdicts, because you don't actually gain any more information out of it, because you already know the verdicts, because you have the judgments. So it's not actually useful without any information to indicate, to be able to analyze your data, because once again, all you're doing is just stacking documents with the verdict that you already know. And if you know the verdict, why would you use such a complicated system, like, with machine learning? So it's you really, for categorization task, and this is the majority of research that has been done so far, you really need to have explainable system, which means that a lot of neural networks that are introduced today are really not able to do so. And so the last one is forecasting, and this is the hardest task in our experience. That would mean that you cannot use the case at all, the final judgment at all, but you can use some other information, like submission by the parties, maybe facts of dependent cases. This is what we used in a different paper for forecasting decisions of the European Court of Human Rights. Sometimes, for instance, if you want to predict a Supreme Court decision, you can use information from a Court of Appeal or something like that. There can be different documents, but they're of course a lot less available for academic research quite often. So, but you would still need to have the judgments, because you need the label to train your system. So let's look at all the papers that we've seen so far, and try to see where they belong on this within those new terms that we tried to introduce. So the first paper is Aletas. So unfortunately, they didn't remove that law part, which contains the verdict. So again, once again, it will say something like the court thinks that there is a violation of Article 6 because of this, this, and that. And then the verdict will be there was a violation of Article 6. So it really contains the references to the judgment. So it's much more like identification task, because it doesn't learn anything other than that. Then Liu Chen and Vicente used the data set of Aletas, so they inadvertently used the same information and also ended up with identification. Kwame and Ramble did a new research, but they don't claim to be removing that information either. So once again, identification task. And Vertucci and Zulia also failed to remove that information from their data. So straight away, we have 6 papers that claim to be predicting court decisions, and in the end, just finding the words that show what the verdict is in the text. So this is quite a gloom picture already. So for categorization, we have really the majority of papers. This is what they're trying to do. But once again, like to reiterate what categorization is, they use the final judgments and are not able to predict any future decisions using them. Moreover, there's a multitude of papers that they were not sure about. These two, for instance, they're doing working on Brazilian court cases. Don't say that they're removing this kind of information, and then we're inclined to believe that they don't, because it's quite a big step always to remove information that contains the verdict, for instance, the arguments of the court. So we assume that they don't. So that's also identification. And within categorization, there's only 3 papers that we know of that actually show some indication of how you can go back and analyze the predictors of the case, which means that the very majority of the papers that come out today, what they do is, once again, they just sort the documents based on, most of them are European Court of Human Rights. So then whether there was a violation or no violation of human rights without adding any additional information, while the court publishes those documents with the metadata that says whether there was a violation or no violation of human rights. So this information is not, is already available, and doing this experiment doesn't add to it. And then forecasting, only 5 papers, one actually from 2015, which I didn't mention before, which worked on the US Supreme Court, which CATES then improved on. So here is the real picture of predicting court decisions. So in reality, there's only 5 papers that do so, and they overwhelmingly have much lower scores than all the papers in categorization report. So I don't remember exactly. CATS is, I think, 70% accuracy. Valto is 57. We report this was not always the main experiment they were doing, but we report between 66 and 70% accuracy as well. So it's much more underwhelming than what is sort of presented as research in predicting court decisions. And it really feels like there has been so much done, but at the same time, the majority of the work is not in reality forecasting any future court decision. Not that they don't have potential to do so. I think even with neural networks, Chalkidis, for instance, they introduced a neural model that can be somewhat explainable, hierarchical attention networks, I believe. So there's a lot of work that can be done in categorization, in identification, and in forecasting. However, the methodology for it has to be chosen carefully, because once again, these papers turn out to be not very useful for real applications. And the papers that did identification really didn't intend to do so, which is a shame. So forecasting turned out to be, from our experience, a much harder task, quite intuitively so as well, because it's hard to predict the future. And of course, the concepts change, and the way that the court judges changes, and it's hard to model this kind of information. And moreover, when you do forecasting, you really don't use any of the court's arguments, and the way that it judges, you can only really use the facts of the case, because you have to use information that's not available before the judgments are made. And that also goes, that's the only input that you get in that case. And of course, it's much harder to get the data for forecasting. With categorization, as soon as the court publishes the cases, you have your data, you can start working on it. With forecasting, you really need to find information that's available beforehand. And of course, it's always harder. So to conclusions, predicting is a very clear term in natural language processing, but it really does not translate well to the real world, at least in predicting court decisions. And so we suggested a way to split the research in this field into 3 fields, and we really hope that people start using these terms or any other more clear terms to indicate what they're doing, because it's really misleading otherwise. And so in reality, there's only very few papers that forecast future decisions of the courts. And it is important to remember that for each task, you really have to think about methodology that is appropriate for that task, so that you actually get something useful in return. And if you have any questions or comments and so on, I'll be happy to answer. And you can contact me. I'll be happy to talk later as well.
Yes, so thank you so much, Masha. May I jump in, Frank? Yeah. So a quick question. So it seems that those matters are quite big in just the volume of text documents, and they are probably went through quite a bit of proper vetting until they got to the court. Is there any research done in, let's say, small court cases, or what would be called the small court cases in UK? These are the claims that are up to, let's say, 10,000 K. Thank you.
So do you mean whether they're like you can predict these things for the smaller court case? In reality, there's actually not that much data even in those courts that I'm describing, because most courts don't publish the data, especially for maybe for Supreme Court. This is what other the European Court of Human Rights, what most people work with. But there's not that many cases to work with either way, especially after you balance the data. So I think it wouldn't really make much of a difference. But this is pretty much all the research there is in predicting court decisions. If any of them are for small courts, we can find out. But this is pretty much it.
Question here.
Go, Frank.
Hey, thank you. Thanks, Masha. That was a great talk. Just a question about categorization cases. So in those papers, nobody's setting aside testing data in a lockbox. They're allowing the testing data to contaminate the training data. Is that the point?
No, not at all. It's just that it doesn't actually mean predicting future court decisions, because if you take the final judgments of the court case, it contains all these facts that were written when the judgment was made. You don't have this information before you actually make a decision, so you can't forecast any future decisions. It's just impossible with that kind of data. So the only reason to do so, to do categorization, is to look back and see, okay, what, to do legal analytics, basically, to go back and see what influenced their certain decision. And that can be done. It's just the methodology has to allow to do so. If it's a neural network, it's much harder to do so.
Yeah, no, that's clear to me. But what I'm saying is, can't you, like when you're developing the training model, the researchers of these categorization cases can set aside a bunch of cases in a lockbox. They don't allow themselves to look at them, and they try to predict or forecast what those decisions will be, and then they can see what those decisions were after the fact. You know what I mean?
That's true, but they're not actually forecasting any future decisions. These decisions were already made.
Right. Okay.
Even the
okay.
ones they put in the logbox, they're already made. It's not future. It's already been done.
That's
But
true, but the
future one
training
is
model
in
doesn't see them.
Yes, of course, but you can't predict the decision that hasn't been done yet. Do you understand
Good.
the problem there?
I do, and I like the subtlety. Yeah.
So you really can categorize them, and of course, this is how you, in categorization task. Of course, you'll have a test set aside. This is how science is done. You really have to do so, and this is how it's done. But it's not in real words of like what we understand by predicting court decisions. It is not true, because those cases, it's this, all of them has been judged already.
Right, and I
So
think
what's
with
the
the
purpose? What's the purpose of finding the, like, predicting the labels of those judgments?
well, you're making the assumption in the categorization cases. I think the purpose is that the assumption is that these unseen cases that are in a lockbox are exactly identical to unseen cases in the future. And you're right to point out that they're not. Okay, and I think that's the interesting.
Because the
That's the
input
interesting
that you
claim.
get, you don't have the facts that you use to predict. You don't have, because those are facts that were rewritten multiple times by different people to get to that judgment. So
that's
you
right.
really can't.
That's right. Okay. All right. Great.
I got very passionate. I'm sorry.
I'm aware that we are a bit over time, but we have many questions from the audience. So if you don't mind staying a bit
About
to answer them, can I get the?
First of all, thank you. I think it's an important task to look at all these papers. I will try to push back on the overall assumption, because I'm a very simple person. I find these what you call categorization, I call classification. I think all the three categories are all the same. It's all classification. I find that highly useful, because my problem is I want to figure out what's going on in our courts, and I need some reliable way to know the outcome of a text. And I have like reliable ways of extracting the judges and the duration and all these covariates, but it's been really difficult to figure out how the case was decided. So you say the only purpose is if I have a transparent way of figuring how the model like knew how the case was decided. I would say if I have a 85% accuracy of that case was decided like positively or negatively, that's good enough for me, because what I really care about is, do I see correlation with the duration? Do I see correlation with the individual judges? So there's a lot of benefit from that type of thing. And I'm thinking what you're like, also the exchange between Masha and Frank has shown. I mean, guys, it's semantics, I would say. It's because people out there, they believe that predict means something, as you've pointed out, means something different than what NLP researchers think it means. So you could say, we should change this and be more honest about it. But I'll say, how about the journalists just like read the paper and then or the lawyers, for a hot second, take a look and say, oh, yeah, they are not forecasting the future, because forecasting the future is magic, but they are doing something. I think it's amazing that you have a model that you can like give text to, and it can find out how the court decided. It amazes me that that works. I think that is what most of these people try to do. And then, of course, people jumped on board and said, this is like, we're trying to replace judges and all that. I would say, and that's my final point, I totally see why what you call identification and categorization are useful tasks, because it helps a lot with research. Prediction or forecasting seems like a pointless task to me, because we already have a European Court of Human Rights. Nobody wants to do that, right? So the people who care most about that seem to be lawyers who have read the paper and now need to say something about it without understanding NLP. So here they go and say, look, they try to replace all these people. So with that being said, not criticizing like the overall conclusion, I'm just saying maybe the others should change their terminology.
This was a lot. I think I worked on this topic for 4.5 years. My dissertation is about to come out. I think it will cover most of the points that you're talking about. But so regarding the fact that maybe it's not the NLP people, but the others that should understand it, the problem is that NLP people also don't understand it. This is maybe the point that I should have made a lot clearer. The fact that these systems are not explainable, and actually NLP people suggest using them for making decisions or for analyzing judges' decisions is a real big problem, because this of course it's cool that you can take a case and see what the judgment is, but if the system is not explainable, you cannot look at the correlations that you're talking about. You cannot say that, oh, I saw that when these judges are there, that this is how the case ends. For that reason, you have to have explainable, to some degree, not necessarily in legal terms, but to some degree explainable systems that you get that you can analyze. If you just, once again, if you just take the documents and try to sort of predict in the categorization task, predict what the judgment is, you're doing the work that has already been done. The court already ruled. There's no need for this in real life. It's other than, oh, cool that you could do it. It's really not, doesn't allow you to do any sort of analytics or any sort of any sort of analysis of that. And the fact that a lot of people did identification without realizing that they had verdicts in their documents, this is NLP problem, not the journalist problem. Why should the journalist understand how data goes into machine learning and what goes on in machine learning? Also, the Alethe's paper has verdicts, like the most famous paper probably in predicting court decision, has verdicts in its data. And everybody keeps citing this paper, even though they use faulty data. It's a really big problem. So like this is sort of the argument that I will make, that all these tasks are incredibly useful, but they have to be done correctly, and they have to really show what they do. And in that sense, this is why I suggest new terminology, so it's very clear that nobody who's doing categorization identification is trying to sort of fool people into thinking that they're going to make a decision predicting system that can tell you the future. And yeah, one small comment in terms of predicting the future. It can be useful as well. Like forecasting can be useful as well. For instance, in the US, so much effort goes into predicting how Supreme Court will judge its decisions before it does, because it has such huge social implications that you really want to know in advance if it is possible. And a lot of people, political scientists, do that all the time. And if there's an automated system that can help them with that, that can be useful as well. So yes.
Thank you. I think two quick questions, if you don't mind. One from Ben from the audience.
Yeah, okay. Just very quickly, more of a contribution to the discussion, really. This reminds me actually of a paper I saw, I think in 2016 at Cells. And Daniel Chen had an algorithm that was trying to predict dissent in the Court of Appeals. And this was the question exactly I asked him, right? Because in a sense, in the real life, there's no out of sample. He needs the opinion to predict the dissent. But until the opinion is out, he can't actually run his algorithm. So the algorithm is really only good for telling us what correlates with dissent to some extent. Second very quick remark is that in terms of forecasting, it's not just of practical significance. I think there's also academic interest. So you don't mention this paper because it doesn't use NLP, but I think in 2004, Kevin Quinn and a few co-authors, they had this Supreme Court forecasting project. And I think they showed that a linear regression actually outperformed a group of experts in forecasting Supreme Court decisions. And the interest is not the fact that, they were able to forecast the decisions, right? But that calls into question, assumptions about legal expertise, et cetera, et cetera. So, I guess it's not really a question. It's just a remark, and to say I enjoy the way you categorize the papers.
I really agree with your points as well. Yeah.
And the final question comes from our audience member in the chat. It's from Karine. Which the question being, how does the algorithm work such that a percentage is churned out, especially when it is info-based? Yeah.
I'm not entirely sure if I understand the question. Um,
Would you like to explain this?
especially on maybe, yeah.
Hi, sorry.
Hi. No,
I
yeah.
wanted to ask, because just now in your presentation you were talking about how like there's a percentage tied to like the accuracy of the predictions, right? So I was wondering like how does that work? Especially because like when you don't have information for like the outcome of the case, how do you like compare it with um your prediction before the outcome is being released? Yeah, so I was wondering how like the algorithm works here. Yeah, thanks.
So this is yeah, something I also mentioned with forecasting, that you really have to have the judgments to get the label to evaluate your system. So basically, for instance, this is what we did for the European Court of Human Rights. We took like the documents that are available before the judgment is made, and we took the labels from the judgments. So that way we could train the system by having the labels from the judgment, so whether there was a violation or not, and take it as earlier documents that describe the case. So we connected them to the labels, and we also had a test set like that. So we had those documents and the labels from some judgments, and so that way we could evaluate how it works. But in reality, we have 5,000 or more of those documents that don't have the judgment yet. So for them, we predicted a court decision, and now we wait. So this is how we can evaluate. We actually have a little website that does so. I don't know. Yeah, I'll put it in the chat, called yurisays.com, which predicts this says.com, which predicts decisions of the European Court of Human Rights continuously, updated every week, I think.